Good day everyone, I am Chair Laputan. Today we will discuss about intellectual property rights. So what is intellectual property rights? Intellectual property refers to creations of the mind. It can be an invention, patent, utility model, a design, industrial design, a brand name, trademark, or a literary and artistic work copyright. Intellectual property rights, or IPR, are the rights given to a person over the creations of their minds. They are usually give the creator an exclusive right over the use of his or her creation for a certain period of time. Intellectual Property Code of the Philippines under Republic Act Number 8293, June 6, 1997, an act prescribing the Intellectual Property Code of establishing the Intellectual Property Office, providing for its power and functions, and for other purposes. The term intellectual property rights consists of copyright and related rights, trademarks and services mark, geographic indications, industrial design, patents, layout design, topographies of integrated circuits, and protection of the undisclosed information. Next. So, patent is an exclusive right granted for a new, inventive, useful product. It can take the form of a new product, process, or technical improvements to existing inventions. So, an invention that is not been invented, we can call it a patent search. An invention patent is a government-issued grant bestowing an exclusive right to an inventor over a product or process that provides any technical solution to a problem in any field of human activity which is new, inventive, and industrially applicable. Benefits of patent. So we have benefits of patent. A patent is an exclusive right that allows the inventor to exclude others from making, using, or selling the products of his/her invention during the life of the patent. So patent owners may also give permission to, or you can have license other parties to use their inventions on mutually agreed terms. Owners may also sell their inventions right to someone else, who then becomes the new owner of the patent. So, eligibility. The Intellectual Property Code of the Philippines sets 3 conditions for an invention to be deemed patentable. First, we have it has to be new, involves an inventive steps, and industrially applicable. Next, how are these defined? In the IP code, an invention is not considered new if it's already formed. So we cannot call invention we cannot call them a patent if it is already existed. So prior art is explained in the Intellectual Property Code of the Philippines, Chapter 2, Section 24 to 24.2. An invention involves an inventive steps if, having regard to prior art, it is not obvious to a person skilled in the art at the time of the filing date or priority date of the application claiming the invention. An invention can be produced and used in any industry is considered industrially applicable. So if it is used in industry, it is an industrially applicable. Term of protection. The term of patent shall be 20 years from filing date of the applications, and patent must be maintained yearly, starting from the 5th year. So it has a duration of 20 years for the patent.
Hi, I am Ana Marie Pico de Sal, the second reporter, and I am going to discuss utility model and industrial design. When we say utility model, just like inventions, is an exclusive right granted to for an invention, but it does not require the condition of the involvement of an inventive step to be protected. A registrable utility model is any technical solution to a problem in any field of human activity which is new and industrially applicable. It may or may not have an inventive step. It is similar to patents. Utility models protect new technical inventions through granting a limited exclusive right to prevent others from commercially exploiting the protected inventions without consent of the right holders. Benefits of utility model. A utility model allows the right holder to prevent others from commercially using the registered utility model without his authorization, provided that the utility model is new based on the registrability report. Compared with invention patents, it is relatively inexpensive, faster to obtain, and with less. In other words, utility models are cheaper to obtain and maintain the rights. The registration process is often simpler and faster without substantive examination. Eligibility of utility model. Any technical solutions of a problem in any field of human activity which is new and industrially applicable shall be registrable. The provisions regarding non-patentable inventions as provided for in Part 2, Rule 2 of Regulations for Patents this provision shall not apply to products and composition for use in any of these methods. Plant varieties or animal breeds are essentially biological process for the production of plants or animals. This provision shall not apply to microorganisms and non-biological and microbiological processes. Provisions under this subjection shall not preclude Congress to consider the enactment of a law providing so generous protection of plant varieties and animal breeds and a system of community intellectual rights protection, aesthetic creations, and anything which is contrary to public order or morality. Term of protection. A utility model is entitled to 7 years of protection from the date of filing, with no possibility of renewal. In general, the requirements for acquiring a utility model are less stringent than for patents. In some countries, the requirements for protecting utility models are basically the same as for patents. That is, they must have within the eligible subject matter, they must be novel, they must involve an inventive step or non-obvious, they must have industrial applicability or utility, and they must be described in an application in a sufficient and in other words, utility model protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without the utility model owner's consent. The above right is territorial. The right can be enforced only within the country in which a utility model is granted. Industrial design. An industrial design consists of three-dimensional features such as the shape or surface of an article, or of two-dimensional features such as patterns, lines, or color. An industrial design is the ornamental or aesthetic aspect of an article. Design, in this sense, made the three-dimensional features. It is a strategic problem-solving process that drives innovations, builds business success, and leads to a better quality of life through innovative products, systems, services, and experiences. The gap between what is and what's possible. Benefits of industrial design. The owner of a registered industrial design has the right to prevent third parties from making, selling, or importing articles bearing or embodying a design which is a copy, or a substantially a copy, of the protected design. When such acts, obtaining exclusive rights to a product with a particular appearance may result in a substantial return on investment because it will allow you to prevent others from reproducing a popular design. Exclusive rights mean only you can make your product and allow you to set your price without being undercut by your competitors. An industrial design registration gives you exclusive rights to the commercial production, marketing, and sale of your product for 10 years from the registration date or 15 years from the filing date, whichever period ends later. It also prevents your competitors from importing a product that copies or very closely resembles your design into. Eligibility of industrial design. In order to be registrable, an industrial design must be a new or original creation. The following industrial designs shall not be registrable. Industrial designs that are dictated essentially by technical or functional considerations to obtain a technical result. Term of protection in industrial design. The registration for industrial design is for a period of 5 years from the filing date of the application. The registration of industrial design may be renewed for not more than 2 consecutive periods of 5 years, each by paying a renewal fee. The fee should be paid within a year of the expiration of the registration. Industrial design registrations are governed by some of the same provisions that apply to patents. See what these are in Section 119 of the Intellectual Property Code of the Philippines. Depending on the applicable laws, independently created industrial design must fulfill some or all of the following criteria: novelty or originality. The assessment of novelty and originality varies from country to country. In general, an industrial design is considered to be new or novel if it has not previously been disclosed to the public, and it may be considered original if it is significantly differs from known designs or combinations of known design features.
So the next component of intellectual property right is a trademark. A trademark is a word, a group of words, sign, symbol, or a logo that distinguishes your business goods or services from those other traders. It also identifies and differentiates the source of goods and services of one entity from those of others. A trademark is used in business to indicate the source of the brand in order to distinguish and identify it in the market. Trademark serves as the customer's guide in selecting the product to buy in the market. It also protects the customers by preventing the public confusion as to where the product originates and the quality of the product. If you're in a business, trademarking is the only way to legally protect your ownership of what you think is your brand. Here are some examples of the trademark brands. So we can see a logo, a sign, and even a taglines that indicates the brand. If you're in a business, distinguishing your goods or services from others gives you a competitive edge. So here we will learn more about trademarks, how to apply for protection, and how to manage them. So first, we will know what are the benefits of having a trademark. So a trademark protects a business brand identity in the marketplace. Registration of it gives the owner the exclusive rights to prevent others from using or exploiting the mark in any way. So when your trademark has been registered, then no one can copy your brand or your product. So aside from being a source of identifier, differentiator, quality indicator, and an advertising device, a protective mark may also bring another stream of income to the owner through licensing or franchising. Next is the eligibility or the qualification of trademarks. So, the Intellectual Property Code of the Philippines prescribes grounds for non-registrability. See the Intellectual Property Code of the Philippines, Section 123. Generally, the distinctiveness of the mark is the key point of consideration. So, in terms of protection, a trademark can be protected in perpetuity if regularly monitored and properly maintained. The period of protection is 10 years from the date of registration and is renewable for a period of 10 years at a time. So every 10 years ang pag-renew ng business owner sa iyang product, sa iyang trademark rather. Another component of intellectual property right is the called copyright. Copyright protects literary and artistic works such as books and other writings, musical works, films, paintings and other works, and computer programs. Copyright is the legal protection extended to the owner of the rights in an original work. Original work refers to the intellectual creation in the literary, scientific, and artistic domain. Among the literary and artistic works enumerated in the Intellectual Property Code are books and other writings, musical works, films and photographic works, ornamental designs or models of manufacture, paintings, sculptures, and other works of arts, as well as computer programs and mobile apps, and etc. So, in short, copyright is the legal right or law that protects the works of the original artist. Ang copyright is siya yung pumuprotekta para hindi pwedeng baguhin, gamitin at pagkakitaan ng iba ang iyong literary and artworks. So, the Intellectual Property Code grants authors, artists, and other creators automatic protection for their literary and artistic creations from the moment they create it. So, registration and deposit of your works isn't necessary, but authors and artists may opt to file for the copyright registration of their work in IPOFIL for issuance of the appropriate certificate of copyright registrations. So, here are the benefits. So, the creators of works protected by copyright hold the exclusive right to use or authorize others to use the work on agreed terms. The right holders of a work can authorize or prohibit its reproduction in all forms, including print form and sound recording, public performance and communication to the public, broadcasting, translation into other languages, and adaptations, such as from a novel to a screenplay or for a film. So once your work have been registered and protected by copyright, walang kahit na sino ang makakagamit o makakuha ng iyong artworks without your permission as the owner of the piece. Kung may lumabag man ito, ay pwedeng makasuhan ng may-ari ng piece. Isa na dito ay ang kasong copyright infringement. So here in the eligibility, works covered by copyright that can be deposited with IPOFIL are, but not limited to, novels, poems, plays, reference works, newspapers, advertisements, computer programs, databases, films, musical compositions, choreography, paintings, drawings, photographs, sculptures, architectures, maps, and technical drawings. In terms of protection, the term of protection for copyright in literary and artistic works and in derivative works is generally the lifetime of the author plus 50 years. However, different rules may apply in works of joint authorship, works of anonymous or pseudonymous works, photographic works, works of applied art, audiovisual works. That's all. Thank you for listening.